the way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country.
But as far as the judgment of this court is concerned, because you
Yes.
were also supposed to...
I'm coming in a minute. If your lordship will just give me 1 minute, how we understood it. Para 16, with, as my lord has therefore noticed, only required the political parties to give all these details. And these details have been given, my lord. If they have not been given, that's between the ECI and the political parties. As my lord, the Chief Justice said, I'm not preparing for a political party. Then, my lord, para 17 was the mechanism. Your lordship said details will be furnished in respect of electoral bonds, the details of such bonds that may be received by a political party. Up to a date for issuing such bonds as per the ministry, that is February 19, will be submitted on or before 3rd of May 19. The seal covers will remain in the custody of the ECI. So, my lord, we had no role to play. Your lordships had put this mechanism in place. In your lordship's judgment, your lordships dealt with the diverse aspects, including the need to preserve some degree of anonymity, and your lordships will not mark that in para 125, where your lordships discuss the electoral trust as a alternative to this system. And in the conclusions, which are at para 218, if your lordships have the compilation, it would be PDF page 76.
Yes.
Your lordships will not say we direct the disclosure of information on contribution received by political parties under the electoral bond scheme to give logical and complete effect to the ruling. On 12th April, the court issued an interim direction order directing that the information of donations received from donations must be submitted by political parties. The court directed political parties to submit detailed particulars of donors against each bond, the amount of each bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date on which such credit has been made. I'm only not saying this to explain how we understood the order. So this correlation between which political party has received money from whom comes in here, because the political party says I have received so much money from so and so. Then it says during the course of hearing, Mr. Sharma said that the ECI has only collected information on the contribution made in 2019 because of para 14 indicates direction was limited to contributions in that year. Your lordship then clarify para 13 and 14 of the interim order are extracted below. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission and shield cover particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date of each such credit. The details will be furnished forthwith in respect of electoral bonds received by a political party till date. The details of such other bonds as may be received up to the date fixed for issuing such bonds, including February 19, May 19, will be submitted on or before May 19, and the seal covers will remain, etc. Then your lordships clarify, para 14 does not limit the operation of 13. 13 contains the direction in unequivocal terms to political parties to submit particulars of contributions received through electoral bonds to the ECI. Para 14 only prescribes the timeline for the submission on the contributions when the electoral bond should be done. In view of the interim order, the ECI must have collected particulars of contributions made to political parties through electoral bonds. In view of our discussion, the following directions are issued. The issuing bank shall stop issuance of bonds, which was done immediately. The SBI shall submit details of the electoral bonds purchased since the interim order by the court till date to the ECI, fully given, Manad. Details shall include the date of purchase of each bond, the name of the purchaser, and the purchaser of the bond, and the denomination of the electoral bond purchase. All these details are given. SBI shall submit details of the political parties which have received contribution through bond since the interim order till the date of the ECI. SBI must disclose each electoral bond encashed by the political parties, which shall include the date of encashment and the denomination of the bond. Now, as we therefore understood this, the political parties have come and said we have received so much from so and so. are the details which we will give will make the database complete so that we have the who purchased, when he purchased, and when they've got. If the numbers are to be given, we'll give them. There's no problem. So according to us, the data.
Mr. Salve, I have a few questions. First, tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time we were directed to preserve anonymity, including we had to take measures that within the bank.
What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you store
In two
it?
silos. Your Lordship noticed that in the next order. So the data maintained in two silos.
You store it in three silos. From your application, it emerges now that you do it in three silos. The first silo is the bond number. The
bond number is only on the bond.
And the third is the redemption.
My lord, bond number is only on the bond, and it is cannot be read except through under a UV light. That was only done, my lord, like authentication, like because it was a bearer bond. That's what was sought to be.
What's the purpose of the alpha? And second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature or is
it a security feature entirely?
In the audit trail, do you also?
No, my lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question. Yes. How does the redeeming branch?
Yes.
How does the redeeming branch?
Yes.
Match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it.
While redeeming it, the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the alphanumeric.
Yeah.
But cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
Malad, you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No, Malad. That's what I'm saying. That correlation was not kept. For the reason, it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done. Their bank account details, etc., etc. Everything is done. That is silo 1, if one may so call it, which is noted in your Lordship. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in it. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
My lord, even in the final judgment.
Say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
My lord, your lordships.
All details.
That's why we came to my lord.
Mr. Salve will clarify to put it beyond any.
No problem. No problem at all.
We will say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed any, you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains.
Details, you have to disclose all details. Let there be no, because the burden should not lie upon the court or the petitioners who say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem. Just that this constant, the media constant beating down and the petitioners giving public interviews saying, we will take the state bank to task and we will show this and we will haul them up for contempt, etc., etc. But we are also public institutions working in this space. And it's all right. People work, people acted on the faith of this. Your lordships granted an interim order saying keep records. It wasn't at that time, I subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your lordships were at that balancing interim order. Now, whether completely you should lift the privacy or remove anonymity, better your lordship felt.
Mr. Salvi, the idea behind the interim order was, in case a writ petition is allowed, then
Yes.
data should come out. And that's what exactly is required, nothing
But
more.
as I must say so, Malad, as out of whatever Malad, the Chief Justice is saying, your lordship will clarify, we will give every bit of information, relevant, not relevant, we'll give every bit of information which we have. So that, Malad, there should be no feeling that SBI is interested in somehow holding something back. I only want, Malad, to share one thing. Malad, your lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing that Lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and may not say give the bond numbers, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so and so, investigate so and so. That is, I don't think, the purpose of your lordship's judgment. That was not what it was meant for. And your lordship will see whatever safeguards need to be put in place.
Just one more
Lord,
thing.
I have 2 minutes, my lord, if your lordship permits. At the outset, my lord, on behalf of the central government, I completely disassociate myself with what Dr. Agarwala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, my lord, on behalf of the central government. Now, my lord, I have something to share, and I have been watching this very painfully, my lord, outside the court. My lord, your lordships sit in kind of a silos. Your lordships are, my lord, in an ivory tower, not, my lord, in a negative sense of the term. But what we know here, my lord, your lordships never come to know. The way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country.